I'm Drew Stevenson, and this is an introductory lecture about the non-delegation doctrine. This will be helpful for my students, whether in administrative law or statutory interpretation and regulation, to understand these concepts before you start reading the non-delegation cases. Keep in mind that the non-delegation doctrine is really about Congress delegating authority to executive branch officials and bureaucrats. So you're sort of giving the keys of the kingdom to unelected individuals in that sense. And what Congress does is they entrust them with, they empower them and give them duties and responsibilities, and then also set some parameters for what they should do or what they cannot do. And for my students, keep in mind that this is a complicated area, right? And in some way, we don't really have a non-delegation clause in the Constitution. And this is a doctrine that has seen some, it probably had its high point in the 1930s, and then the high court sort of backed off from it. So let's take a look though, because it does come up in the cases about administrative law and regulation. So first of all, when we're talking about the non-delegation doctrine, we're talking about a challenge to the statute itself. That is, we're attacking what Congress's work product, not an action or decision by an agency. In some of these cases, the petitioners are also challenging an agency decision or agency action, but the non-delegation part of the case is an attack on what Congress enacted, not what the agency did, even though the congressional enactment is what created and gives power to the agency. So a non-delegation challenge is not an attack on an agency action, it's an attack on the agency's enabling statute itself. This is part of why these are sort of high stakes legal discussions, because you're asking the court to throw out a statute that was passed by the duly elected legislature. And this brings up all sorts of concerns for the courts about judicial activism, or at what point they should defer to the legislature or be faithful agents of legislative intent. Because when they're overturning a statute on non-delegation grounds, they're saying that it is unconstitutional. In statutory interpretation, we have a long-standing canon of judicial interpretation or jurisprudence that we call the avoidance canon. And one permutation of the avoidance canon is that courts should avoid reaching constitutional issues or deciding that a statute is unconstitutional if they can decide the case on technical or other grounds. And so a non-delegation challenge, it kind of is in contrast or has friction with the avoidance canon, the idea that courts should overturn or hold statutes unconstitutional only when they have to. Next, keep in mind that the constitutional challenge that we're talking about in the non-delegation doctrine is really based on the separation of powers, or the vesting clauses. Again, there's no separation of powers clause in the Constitution. Instead, the separation of powers is an idea derived from what we call the vesting clauses. In other words, at the beginning of the first three articles of the Constitution, and it'll say the legislative power is vested in Congress, the executive power is vested in the president, and so forth. And so that's where we get our checks and balances, or separation of powers between the branches of government. And that's from that, we also derive the non-delegation doctrine. And the original non-delegation doctrine idea is that one of these branches that has been vested with authority by the Constitution can't give that to one of the other branches. In other words, the framers wanted to have Congress vested with the power to make the laws. And so it would be a problem if Congress just decided, we're tired of making laws. How about we just let the president make all the laws, and then we can all go home and vacation for the rest of the year. Well, the problem is that the power was vested in the Congress to make the laws. And so therefore the non-delegation doctrine is about that. It's essentially about interbranch transfer of powers that were specifically entrusted to one branch. The legal test for non-delegation cases is the intelligible principle test. And this is the point that you're really going to need for your final exam or midterm or things like that. And so the court has a test that it uses for non-delegation cases or challenges, which is, does the statute provide some intelligible principle that restrains the agency and sets some boundaries for the agency? And that in turn gives the court a benchmark to evaluate what the agency did in this case. And now please note that this is an easy standard and almost anything seems to satisfy it. Okay, a little bit of history here. I know some of you hate history, but I'll just give you the basics that you need in the background for these cases. First, the early sources about this cited John Locke's writings. So John Locke was a political author who was a favorite author of the founding fathers or the framers. And they would quote John Locke's writings. And John Locke has a famous passage where he says the legislature can't turn over the legislative power to another branch of government. There were a few cases, very few, about the non-delegation doctrine before the New Deal era. And so one of those is the J.W. Hampton case that I've made another video about. Now, the Supreme Court invoked the non-delegation doctrine in 2 or 3 cases in the late 1930s to invalidate New Deal statutes. And this was kind of a big shock. They hadn't used the doctrine. They had talked about the doctrine, but hadn't used it to invalidate legislation until the New Deal. And they only did it in a few cases. And then never again. The Supreme Court never again invalidated a statute on non-delegation grounds, although some lower courts do. So we do have a few circuit court decisions where a court says this is an inappropriate delegation of power, and they have overturned a statute or an ordinance or something like that. But the Supreme Court hasn't. Also keep in mind that some state Supreme Courts have invoked a non-delegation doctrine in invalidating state statutes. So it would be a misnomer in that sense to say that the doctrine has been dead since the 1930s, since the Schechter-Poultry era. Because it's actually alive and well, not that common, but it is alive and well in the lower courts and the state courts. Now, the other thing my students should be aware of is that there has been a modern revival of the doctrine by some conservative scholars and judges, and especially those with sort of a libertarian or anti-regulation bent, because they view the non-delegation doctrine as a very powerful tool to rein in the administrative state or the sprawling federal bureaucracy, because we're basically going to say your enabling statute is invalid, or this part of your statute, this thing that Congress has given you the power to do, you're not allowed to do. Congress wasn't allowed to give you that authority or power. So you should be aware that we now have some justices on the US Supreme Court who have been have made express statements in their writings and in some concurring and dissenting opinions that they want to revisit the non-delegation doctrine and start applying it more aggressively, but they haven't been in the majority up till now. And similarly, there are some very famous law professors that have published articles in recent years advocating for sort of a revived, more aggressive form of the non-delegation doctrine. The other thing my students should note by way of background is that we have the traditional non-delegation doctrine, as I said, was grounded in the separation of powers, and the fundamental concern is about one branch of government giving its power to another branch. And we're almost always talking about the legislature giving its power to the executive branch or the judicial branch. There are other types of delegations that are to private parties, and this was part of the issue in the ALA Schechter-Poultry case, where you have a private trade association that comes up with a code, and then the president would just adopt their code and force it on the whole industry. We also have cases where the the state or a government agency essentially outsources certain decisions to a private company and lets them decide that. So as an example, the Customs and Immigration Service in the 1990s had outsourced the processing of visa applications to some private for-profit companies. And the 9/11 hijackers, the ones that flew the planes into the Twin Towers and the Pentagon, received their student visas to attend flight school actually from a private for-profit company in the United States that had been hired to process visa applications. And so, as you can imagine, we have a lot of privatization and delegations to private parties when we have things like private prisons or privatized prisons and privatized detention centers for immigrants. And this you could call this a non-delegation problem. The courts have generally been framing it as a due process issue, but you should be aware that there is a type of delegation here and that it presents somewhat different issues than interbranch delegations of authority. Now, why did the non-delegation doctrine disappear for decades from the Supreme Court? Well, I have 4 quick points for you. First, remember the US Supreme Court way back in J.W. Hampton adopted a pretty loose standard for this, the intelligible principle standard, that rendered the doctrine meaningless or ineffective most of the time as a rule. In other words, it's really easy to meet this standard. So because it's such a flimsy rule, it's not going to matter that often. The other thing to keep in mind is it's possible that Congress took note of the non-delegation doctrine in the 1930s when the court invoked it and decided to just make sure that they included some intelligible principle in all their statutes from then on. So sometimes Congress responds, learns from the Supreme Court decisions and adjusts their legislative drafting accordingly. So maybe they just learned to write statutes that avoid violating the non-delegation doctrine. If you know the non-delegation doctrine is out there, then it's not that hard to write your statute in a way that won't violate it. Also, keep in mind that we passed in the 1940s the Administrative Procedure Act and a number of other laws. We also developed some judicial doctrines like Chevron and the Hard Look Doctrine that do a lot of the work of the non-delegation doctrine. In other words, the non-delegation doctrine was a concern that Congress was just turning over its lawmaking power to bureaucrats and regulatory officials. And well, those same bureaucrats and regulatory officials now have to go through a lot of procedural steps and hoops in order to do what they do. We've ensured judicial review of their actions for parties affected by an adverse decision. We have other doctrines that force agencies to explain themselves, explain when they change their position abruptly, or when they're promulgating a new regulation kind of out of the blue, or rescinding a regulation, a long-standing regulation. We have a number of procedural safeguards they have to afford private individuals when they do administrative hearings, like a Social Security hearing or a workers' compensation hearing. And so all of these things actually address some of the same animating concerns that were behind the non-delegation doctrine in the first place, and have satisfied some of the judiciary's nervousness about what was happening. Also keep in mind that we don't have the same judges that we did in the 1930s, right? The judges in the 1930s were holdovers from the Lochner era and were very resistant to the sweeping changes brought in by the New Deal. And since then, we've had generations of judges who went to law school and learned about the reality of the administrative state, and learned that there's regulations and executive branch agencies and an Administrative Procedure Act and so forth. So the judges grew up in a world where this was normal, the judges today, and have a different ideology. And even conservative judges who want to go back to the pre-New Deal era, you can't really go back in a time machine and get the same brain that someone had 100 years ago, right? You have to, you can try to get back to your roots, or renounce the developments of the last few decades, but you're still a modern person, and it's still a new version of maybe an old idea. So judges today don't have the identical mentality or worldview that the judges did during the era when they were invalidating statutes on non-delegation grounds. Okay, that concludes our quick introduction to the non-delegation doctrine.